Nwadike, yes.
My appearance is for the defendant, my lord.
Thank you. Is the claimant aware? Did you call the claimant's counsel?
Yes, my lord. My family, I called him and I sent him the link.
Okay, well, he's not here. Okay, thank you. So I'll proceed to deliver the judgment, and I'm going to be reading directly from my system.
I've copied. I've copied.
Thank you. So the claimants instituted this suit by the complaint filed on 16 February 2023, wherein they sought the following claims. There are 11 claims sought, some of which are declaratory and some monetary. I would not bother reading them. They're already embedded in the body of the of the judgment. I have also summarized the case of the claimants, as well as the defense of the defendant. Also, I have touched on the written addresses of the parties. I'll go straight to my decision. After examining the evidence adduced by the witnesses in this suit, the sole issue which arose for determination is whether the claimants have proved the claims sought by them and therefore entitled to the grant of the claims. The claimants were first employed by the defendant via the letters dated 26 April 2014, and then by another letter dated 30 December 2016, the claimants were offered employment by the defendant. These letters are Exhibits 1, 2, and 3A and 3B. The claimants worked with the defendant until by letters dated 5th September 2022, the claimant's employments were terminated by the defendants. The letters of termination of the claimant's employments are Exhibits 5A and 5B. They instituted this suit after the termination of their employment, and the claims sought by them revealed that their complaints in this case comprise of three aspects. They have complained of wrongful termination of their employment, non-payment of their gratuity, and the discontinuation of the first claimant's medical treatment for the injuries sustained at work. I will first consider the case of the claimants with respect to the termination of their employment. In Relief 1, the claimants sought a declaration that the termination of their employment was illegal and in violation of paragraph 15.3.1 of the Defendant's Employees Handbook. In Relief 4, the claimants sought an order setting aside the termination of their employment and allowing them to resign their appointments instead. The case of the claimants with regard to the termination of their employments is that when they were given the offer of employment dated 30 December 2016, that is Exhibits 3A and 3B, a document titled Company Conditions of Service / Employee Handbook was issued along, containing the terms regulating their employment. During their service in the defendant, they were never queried or issued warning relating to any misconduct, and they were also not found culpable on any allegation, nor violated any provision of the conditions of service or breached any policy of the defendant. But on 5th September 2022, they received letters of termination of their employment from the defendant. According to the claimants, paragraph 15.3.1 of the said employee handbook has set out the grounds for termination of employment, but the termination of their employment was not anchored on any of the grounds. For this reason, the claimant said their employments were terminated without any justification and in breach of the provisions of paragraph 15.31 of the conditions of service. The claimants tendered the conditions of service to employee handbook is in evidence. It is Exhibit 4. In defense of this aspect of the claimant's case, the defendant averred that it terminated the employment of the claimant on the basis of clause 6 of the employment letter, which permits either the employer or employee to terminate the contract by giving 1 month's notice prior to termination or paying 1 month's salary in lieu of notice. The employments of the claimant were terminated in accordance with the provisions contained in the employment letters, and they were paid 1 month's salary in lieu of notice. The defendant, however, averred that the offer of employment issued to the claimants spelled out the mode of termination of the claimant's employment, while the reviewed conditions of service / employee handbook serves as additional guide on other modes of termination. From the case of the claimants, the only reason they have challenged the termination of their appointment is that their employment was not terminated on the basis of any of the grounds stipulated in paragraph 15.3.1 of the employee handbook. This is the reason the claimants contended that the termination of their employees violated the provision of paragraph 15.3.1 of the handbook. On the other hand, the defendant averred that the claimant's employment were terminated pursuant to clause 6 of the claimant's employment letters. I have seen the letters of termination of the claimant's employment, both dated 5th September 2022. They have similar contents, which is to the effect that the services of the claimants were no longer required with immediate effect. The letters also contain the benefits payable to the claimants, comprising of leave allowance, 13th month, 1 month basic salary in lieu, and September 2022 net salary. Going by the content of the termination letters, the claimant's employment were terminated with immediate effect, and the reason for termination is services no longer required. The defendant also computed the claimant's terminal benefit to include 1 month basic salary in lieu of notice. Now, the claimants insisted that the termination of their employment violated the provision of paragraph 15.3.1 of the handbook, which is Exhibit 4. There is, however, a dispute in this case as to which was the applicable condition of service or employee handbook regarding regulating the employment in the defendant as at the time of the termination of the claimant's employment. While the claimant said Exhibit 4 handbook issued to them in December 2016 was the applicable condition of service, the defendant averred that there was a revised handbook in 2021, which is Exhibit 16B and 16C, and that this was the applicable condition of service. Thus, to properly determine the claimant's allegation of wrongful termination of their employment, it is necessary to first determine which of the two handbooks was the valid and applicable condition of service at the time of termination of the claimant's employment. CW2 told the court that the conditions of service / employee handbook issued to them by the defendant on 30th December 2016 remained the only condition of service regulating their employment with the defendant up till the time their employments were terminated on 5th September 2022. He further stated that the general mail from corporate communications on 6 May 2021 was merely to notify the employees of the proposed revised condition of service, which the defendant dated 2nd March 2024. And the general mail clearly stated that the proposed revised condition of service was only for reading and consultation, although they acknowledged receipt of the proposed revised condition of service, but it was for reading and consultation only, as instructed in the general mail. By agreement of the claimants and the defendants, the implementation of the proposed revised condition of service was to take effect from 2nd March 2024. Thus, they never accepted the immediate implementation or the retroactive implementation of the proposed revised condition of service. On his part, DW1 testified that there was an employee handbook issued to the claimants upon their employment, but on 6 May 2021, the Corporate Communications Department of the defendant The revised condition of service to employee handbook was issued to the claimants, and they acknowledged same on 22nd May 2021 and 23rd May 2021 respectively. According to DW1, the revised employee handbook Exhibit 16B and 16C is the applicable and subsisting documents guiding the employment of staff in the defendant. Now, it is not in dispute that when the claimants were issued the appointment letters of 30th December 2016, they were also issued copies of the employee handbook. This is the one in Exhibit 4. It is also not in dispute that the claimants received the general email of 6 May 2021, wherein the defendant notified his employees of a revised employee handbook, which was attached to the mail. The email is Exhibit 16A, and it required staff of the defendant to sign and return. The acknowledgement page of the revised employee handbook to indicate this to the staff, to indicate that the staff had received, read, and understood the handbook. The claimant admitted in their reply to the statement of defense, as well as in the evidence of CW2, that they acknowledged receipt of the revised employee handbook. I've also seen the pages of Exhibit 16C, B, and 16C, where claimants acknowledged receipt of the handbook. The first claimant acknowledged receipt of the handbook on 23rd May 2021, while the second claimant acknowledged receipt of the handbook on 22nd May 2021. From the facts and evidence placed before me, it is clear that the claimants were informed of the revised handbook and they were issued copies of the handbook which they received and acknowledged. The claimants contended that the handbook was future dated to 2nd March 2024, and for this reason they averred that it was not for immediate implementation. By the content of the email forwarding the revised handbook to the staff of the defendant, it discloses that the handbook had already been revised, and it was being forwarded to the staff to read and understand it. There was no indication in the email that the handbook was a proposed handbook. Contrary to the claimant's assertion that the revised handbook was for reading and consultation only, it was actually a fully revised handbook released to regulate employment in the defendant. To buttress this fact is the content of the claimant's acknowledgement of the handbook. The statement signed by the claimants in the handbook reads thus: acknowledgement of receipt of employee handbook. I have received the current company employee handbook and have read and understood the material covered. I have had the opportunity to ask questions about the policies in this handbook, and I understand that any future questions that I may have about the handbook or its contents will be answered by my supervisor manager or his or her designated representative upon request. I agree to all and will comply with the policies, procedures, and other guidelines set forth in the handbook. I understand that the company reserves the right to change, modify, or abolish any or all of the policies, benefits, rules, and regulations contained or described in the handbook as it deems appropriate at any time, with or without notice. I acknowledge that neither the handbook nor its contents are an express or implied contract regarding my employment. I further understand that all employees of the company, regardless of their classification or position, are employed on at-will basis, and their employment is terminable at the will of the employee or the company at any time, with or without cause, and with or without notice. I have also been informed and understand that no officer, agent, representative, or employee of the company has any authority to enter into any agreement with any applicant for employment or employee for an employment arrangement or relationship other than on an at-will basis, and nothing contained in the policies, procedures, handbooks, or any other documents of the company shall in any way create an express or implied contract of employment or an employment relationship other than the one on an at-will basis, unquote. By this statement, the claimants knew that the revised handbook is the current handbook They also undertook and agreed to comply with the policies, procedures, and other guidelines contained in the handbook. I've heard CW2 say that they never I have heard CW2 say that they never accepted the immediate implementation of the revised handbook. This allegation has, however, been rubbished by the claimant's signed acknowledgement of the handbook, where they stated clearly that the revised handbook is the current employee handbook. Besides, the claimants have not proved that they protested in any way to the defendant or communicated any rejection of the implementation of the handbook to the defendant. With respect to the claimant's allegation that the revised condition of service was not to take effect until 2nd March 2024, firstly, the claimants have not proved the agreement CW2 said they reached with the defendant that the implementation of the revised condition of service was to take effect from 2nd March 2024. Secondly, I have examined the revised handbook thoroughly, but I cannot find where the commencement or effective date is stated to be on 2nd March 2024. I have observed that the claimants based their allegation that revised handbook was to take effect from 2nd March 2024 on the date written on the approval page of the handbook. On the approval page, which is the last page of the revised handbook, 4 management staff of the defendant signed the approval page, but only one of them, the company secretary, wrote a date against his signature. The date he wrote is 2/3/2024. This is what the claimants took to mean the effective date of the handbook. It should be remembered that this handbook was released to the staff of the defendant since 6 May 2021. It means that it had been signed before it was released to staff. The date written by this company secretary against his signature is meant to be the date he signed the document, which date, in my view, was clearly in error. In any event, there's nothing in the handbook which indicated that the date the company secretary stated against his signature is the date the handbook was to come into operation. It is clear to me from Exhibit 16A that the revised handbook took effect from the date it was circulated to the staff of the defendant via the email of 6 May 2021. It is therefore apparent from the foregoing that the handbook the claimants were issued on 30th December 2016 had been revised by the handbook issued to them on 6 May 2021. The claimants were aware of the revised handbook. They have copies of it and they agreed to comply with the terms and conditions contained in the revised handbook. Accordingly, from the effective date of the revised handbook, the earlier handbook of 30th December 2016 no longer operates as the condition of service in the employment of the defendant. The operative handbook in the employment of the defendant as at the date the claimant's employments were terminated on 5th September is the revised handbook, which is Exhibit 16B/16C. The claimants funded their allegation of breach of the condition of service in the termination of their employment on the earlier condition of service. It implies that they have brought their case on the basis of a wrong and discarded condition of service. That is to say, their case should end here. I have observed, however, that the provisions of paragraph 15.3.1 of Exhibit 4 handbook, upon which the claimants anchored their allegation of wrongful termination of their employment, is also contained in the revised handbook. The claimants averred that in paragraph 15.3.1 of Exhibit 4, the grounds for termination of employment include consistent failure to meet the agreed level of performance established for the employee's position, or if the employee is found guilty of a misconduct or breach of company's rules and regulations, or where an employee is medically certified to require psychiatric help or is experiencing a nervous breakdown. I have seen the provisions of paragraph 15.3 of the revised handbook. The provisions are the same with those of paragraph 15.3.1 of the former handbook. Paragraph 15.3 of the revised handbook provides thus, amongst others. The company the company can also terminate an employee's employment for any of the following reasons. One, consistent failure to meet the agreed level of performance established for his or her position. Two, if an employee is found guilty of a misconduct or breach of company's rules and regulations. And three, where an employee is medically certified to require psychiatric help or is experiencing a nervous breakdown. These are the same reasons given by the claimants for alleging that their employments were wrongfully terminated. It is the case of the claimants that the termination of their appointments was not based on any of these grounds specified in the condition of service for termination of their employment. The opening statement in the above reproduced portion of paragraph 15.3 of the revised handbook permits the defendant to terminate the employment of its staff other than on the grounds specified in the provision. In other words, the reasons specified in paragraph 15.3 of the revised handbook for which the defendant can terminate the employment of his staff is not closed. Therefore, the defendant may terminate the employment of any of its employees for reasons outside those stated in paragraph 15.3 of the revised handbook. For example, the preceding provisions of paragraph 15.3 of the revised handbook made provision for giving of notice or payment of salary in lieu of notice to terminate the employment. Therefore, the defendant may terminate the employment of any of its staff by giving the required period of notice or payment of salary in lieu of notice without necessarily basing the termination on any of the grounds specified in the paragraph. Accordingly, the fact that the defendant terminated the employment of the claimants for service no longer required, which is not one of the grounds for termination of employment provided in paragraph 15.3 of the revised handbook, does not amount to breach of the condition of service, nor can it be considered as rendering the termination wrongful. Let me add that in master and servant employment, as existed between the claimants and the defendant is not restricted to terminate within the grounds stated in the handbook. It is the law that in such an employment, both parties there to have the right to terminate the contract at any time and for any reason or for no reason at all. See Texaco Nigeria PLC versus Kehinde, 2002. Ikale versus Fan, 2003. Thus, the defendant is entitled to terminate the claimant's employment with or without any reason. It is where a procedure is provided in the employment contract for the termination of the contract, but it was not followed that the termination amounts to wrongful termination. Clause 6 of the claimant's employment letters of 30th December 2016 provides that either the claimant or the defendant may terminate the employment by giving a 1 month notice in writing or payment of 1 month's basic salary in lieu of notice. According to the defendant, the claimant's employment were terminated pursuant to this term of the employment contract. The letters of termination of the claimant's employment show that the employments of the claimants were terminated with effect from 5th September 2022, the same day of the letter. The claimants were also informed that they were to be paid 1 month's basic salary in lieu of notice. In cross-examination, both claimants confirmed that they were paid 1 month's salary in lieu of notice after the termination of their employment. It is therefore clear that the claimants' employments were terminated in accordance with the terms of their employment in the letter of employment, and the defendant complied with the requirement for payment of salary in lieu of notice. From the foregoing, I find that the claimants failed to prove that the termination of their employment was done in violation of the terms and conditions of service, which regulated their contracts of employment with the defendant. My further findings reveal that the termination of the employment of the claimants was not wrongful, as it was done in accordance with the terms and conditions of the claimant's employment contracts. In Relief 4, the claimant sought an order setting aside the termination of their employment and allowed them to resign their appointments instead. The claimants have not made out any case that will necessitate that the termination of their employment be set aside. The defendant had exercised its right under the contract to terminate the claimant's employment, I find no fault in the exercise of that right as to interfere with the termination of the claimant's employment. Consequently, I hold that the claimants failed to prove the declaration and the order they sought in reliefs 1 and 4 of their claims. In the claimant's belief that their employments were wrongly terminated, they sought an order directing the defendant to pay each of them the sum of 10 million naira as general and punitive damages for breach of their employment contracts. This is in relief 9. My finding in this judgment that the claimants did not prove wrongful termination of their employment affects this claim. The claim also fails. In relief 5, the claimant sought an order directing the defendants to compute and pay to them their outstanding salaries and other emoluments from the date of the termination of their employment until they are allowed to resign voluntarily. By this claim, the claimants consider their employment to be subsisting till date. It is now obvious to the claimants that their employments were validly terminated and they ceased to be employees of the defendant since 5th September 2022. They do not have a subsisting contract of service with the defendant. It is right that a servant whose employment has been terminated cannot claim for salary for periods he was no longer in the employment. See Oboth versus CBN. See Springbank versus Babatunde, 2012. The result is that the claimant's claim in relief 5 also fails. Another aspect of the claimant's case is their claim for payment of gratuity. This is constituted in reliefs 2, 6, and 7 of their claims. In reliefs 2, the claimants asked the court to declare that the defendant is under illegal obligation by virtue of paragraph 19.6.3 of the Employees Handbook to pay the claimant's gratuity as part of their terminal benefits. In relief 6 and 7, the claimants sought payment of the sums of 12,455,094.49 and 14,615,009.00 to the first and second claimants respectively as their gratuity. In his evidence, CW1 stated that they worked with the defendant for over 9 years, from 1st November 2013 to 5th September 2023. I think that should be 2022. 5th September 2022. Sorry about that. When their employments were terminated by the defendants, by virtue of paragraph 19.6.3 of the condition of service, they are entitled to 2 months gross salary for each year served in the defendant as gratuity. In response to this claim, DW1 testified that the claimants are not entitled to payment of gratuity under the revised handbook because the handbook no longer recognizes gratuity as part of the benefits and compensation to be paid to employees. In cross-examination, CW1 confirmed that the revised handbook did not make provision for gratuity. I have also examined the revised handbook and observed that it does not contain any provision for payment of gratuity as part of the terminal benefits of the employees of the defendant. Thus, when the claimant said they are entitled to be paid gratuity by virtue of paragraph 19.6.3 of the condition of service, it seemed they founded the claim on the former handbook, Exhibit 4, which ceased to operate since the coming into effect of the revised handbook in May 2021. As at the time of termination of the claimant's employment in September 2022, the extant handbook, which contains the terms and conditions regulating their employment, did not make provision for payment of gratuity to them as part of their terminal benefits. I have also examined the claimant's employment letters. They do not contain any item entitling the claimants to payment of gratuity upon termination of their employment. Therefore, I find that gratuity is not one of the entitlements payable to the claimants under the condition of service. upon termination of their employment. The result is that the claimants failed to prove the claims in Reliefs 2, 6, and 7. There are also claims sought by the first claimant regarding injury he sustained while performing his duties for the defendant. These are the claims in Reliefs 3 and 8. The law is settled that the burden of proof in on the party who makes the assertion and that is entitled to the relief sought by the strength of evidence adduced by the party. See sections 131, 132, and 133 of the Evidence Act 2011. See also the case of Umel Jacob versus Ezenamo 1990, Womiloju versus Anibire 2010. Thus, the burden of proof on the declaration sought by the first claimant in Relief 3 is squarely on him. The evidence in proof of these affirmance was given by the second claimant, who said on 28 June 2022, when the first claimant was carrying out his responsibility for the defendant, he had an accident at the defendant's plant in Jeba, Niger State, and was referred to Cedar Crest Hospital in Abuja for further investigation and treatment. An incident investigation report was generated by the head of department of the first claimant to officially notify the defendant of the accident. The first claimant's treatment was discontinued by the doctor engaged by the defendant following the termination of his employment on the 5th September 2022. In his own evidence, the first claimant, who the claims relate to, said he never broke any caution barrier and was never comprehensively treated after the fall from the height. The defendant intentionally doctored the incident investigation report and downgraded the severity of the injury in order to evade sanctions from regulatory bodies. He was still undergoing medical treatment for the injury he sustained as a result of the accident he had while carrying out his job for the defendant when his employment was terminated. From the day of the accident, he has been on continual medical appointments as a result of the injury. The first claimant tendered the referral from incident investigation report and medical report in evidence. These are exhibits 8, 9, and 12 respectively. In defense of these claims of the first claimant, DW1 stated in his evidence that the first claimant had an accident at the defendant's plant in Jeba, Niger State, and the first claimant was attended to by the medical staff at the defendant's plant. The first claimant was admitted to the hospital at the defendant's plant, where he underwent medical examinations, which included various body scans to detect possible injuries resulting from the accident. The first claimant was treated adequately for the injury he sustained as a result of the accident. Despite the negligence of the first claimant, which resulted in his accident, the defendant undertook to pay for his medical services while he was an employee of the defendant until he was fully healed of his injury. The first claimant has on numerous occasions filled the medical refund forms, and the defendant adequately reimbursed him for any medical expenses incurred. DW1 tendered copies of hospital bills in evidence as Exhibit 19. DW2 also testified on this matter and said the first claimant had an accident at the defendant's plant in Jeba, Niger State, and the first claimant was attended to by the medical staff at the defendant's plant. She carried out an investigation into the accident and she issued a report. She said it was the negligence of the first claimant that resulted in his accident. The first claimant was admitted to the hospital at the defendant's plant, where he underwent medical examinations, which included various body scans to detect possible injury resulting from the accident. The first claimant was treated adequately for the injury he sustained as a result of the accident, but it was discovered that the first claimant had a pre-existing polycystic kidney condition, which necessitated him being referred to a nephrologist at Cedar Crest, Abuja. The defendant undertook to pay for the first claimant's medical services while he was an employee of the defendant until he was fully healed of his injury. DW2 tendered incident investigation report and medical report in evidence. They are Exhibits 21 and 22 respectively. From the evidence of all the witnesses, it is not in dispute that the first claimant had an accident at the defendant's workplace while working for the defendant and sustained injury in the accident, even though the nature of the injury was not disclosed by the claimants either in their pleadings or evidence. The nature of the accident, which was said to be a fall from a height, although the claimants wants this court to declare that the failure of the defendant to make that the failure of the defendant to make necessary arrangements for his medical treatment or continued medical treatment constitutes an unfair labor practice. It is, however, not in dispute that the defendant gave medical treatment to the first claimant for the injury, but the treatment was stopped only when the first claimant's employment was terminated on 5th September 2022. CW1 stated in his evidence when he said after the accident, the first claimant was referred to Cedar Crest Hospital in Abuja for further investigation and treatment. But the first claimant's treatment was discontinued by the doctor engaged by the defendant following the termination of his employment on 5th September 2022. The first claimant, as CW2, also confirmed this fact when he said he was still undergoing medical treatment for the injury he sustained as a result of the accident when his employment was terminated. It is therefore clear from the evidence of the claimants that the defendant attended to the claimant medically for his injury until his employment was terminated. The claimants failed to prove that the defendant failed to make necessary arrangements for the treatment of the first claimant after the accident occurred while he was in the employment of the defendant. The first claimant's treatment was stopped when his employment was terminated. The question is whether the defendant has the responsibility to continue to give the first claimant medical treatment after the termination of his employment. This question will be answered together with the claim in Relief 8. By the claim in Relief 8, what the first claimant wants this court to do is to order the defendant to continue to treat him perpetually simply because he sustained injury in the course of his employment. In cases of injury in workplace, the employment can make only two types of claims with respect to the injury. The employee can either file a suit in this court to claim damages for breach of the employer's duty of care resulting to the injury, or claim for compensation under the Employee Compensation Act. Now, the first claimant's case with respect to the accident in the workplace is not a claim for damages for negligence of the defendants, the resulting to the injury. In fact, the claimants did not attribute the accident to the fault of the defendant in any way. Rather, it is the defendant who claims that the accident happened as a result of the negligence of the first claimant. The first claimant's case with respect to the accident is also not brought under the Employee Compensation Act for compensation for the injury. As I have said before, the first claimant's case is not also that the defendant neglected him and failed to give him medical treatment after the accident. In addition, the first claimant has not proved that the injury he sustained in the fall is a disabling, incurable injury or a permanent disability. I have seen the receipts, medical reports, and test reports put in evidence by the first claimant. These are Exhibit 12, dated 2022 and 2023. None of these documents show that the first claimant's injury from the fall is an incurable injury or a permanent disability. Therefore, now that the first claimant is no longer an employee of the defendant, this court cannot order the defendant to continue to treat the first claimant for the injury which has not even been shown to have resulted from a negligent act of the defendant. The mere fact that the first claimant sustained injury at work does not mean the defendant will shoulder the responsibility of his treatment forever. The proper claim the first claimant ought to have brought after the termination of his employment is one for compensation for the injury, which should have been made to the Nigeria Social Insurance Trust Fund Management Board under the provisions of the Employee Compensation Act, in view of the termination of contract of employment between the first claimant and the defendant. The defendant is not under obligation to continue to shoulder the first claimant's medical treatment. This also means that his claim in Relief 8 cannot be granted. I have also considered the claims sought by the claimants in Reliefs 10 and 11, and I find that they too have not been proved. These claims also fail. The result of the foregoing findings of this court is that the court finds no merit. The court finds no merit in the case of the claimants. Accordingly, this suit is dismissed. No order as to cost. Judgment is entered accordingly.
Thank you, my lord, for your judgment. We are most grateful.
Thank you. So you'll be able to get signed copies of your judgments by Monday. All right.
Grateful, my lord. Much obliged.
Thank you. Thank you. The claimant, is the claimant's counsel in court now?
Yes, with profound respect, my lord.
Yes.
Sorry, I was in another court when the court started sitting. I'm so sorry about that.
Okay.
Femi Adedeji.
Okay.
I appear for the claimants.
Thank you.
Most obliged, my lord.
So you have copies of your signed copies of your judgment by Monday. All right.
As the court pleases.
As the court pleases.
Thank you very much. I guess the court will rise now. Have a nice day, everyone.
Thank you, madam.
Thank you.
You too, ma.
Thank you.